Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to my Muslim student. Hi everyone. I hope everyone is in good condition. Alright. Today we are going to start with our new topic. We call this one as law of thought. So before we proceed to the topic for the law of thought, let's go through the type of the liabilities and introductory of law of thought. This topic actually have been highlighted earlier in lecture number 1 when we talk about basic type of the law and basic type of the topics that we are going to focus this semester. Okay, as the learning outcome for this topic, I expect all my students to at least identify what are the liabilities available under the law, and then because we are going to focus on the tortious liability, you may be able to identify the example of the tortious liabilities. Okay, if you are talking about liabilities, but this time we are talking about tortious liabilities. Last time we have focusing on few types of the liability under contract. So today, tort liability or tortious liability will be covered. So when we talk about tort liability, this is something that is yet to be carried out. Okay, you see the word liable. This is always be something that you have to be responsible with. Let's say we are talking about you are liable under the tortious liability, means you have to be responsible under that particular liability. Okay, the word liability itself is also referring to the obligation that is yet to be carried out. The obligation or something that you have to do because of your action. Okay, there are a few issues that you have to consider when we talk about tortious liability, because it is not only limited to the contract provision, but there are certain scenarios where it is required intention. Some scenario not required intention for you to be able to claim under tortious liability. I give you one simple example. Let's say you accidentally hit someone. You don't have any intention to do that, but another party can claim from you because tort is not limited to the intentional liability. But there are scenario for example that I gave you before, negligently accident or hit someone, that is also maybe considered as tortious liability. You have to be responsible for that particular action. The example of the intention liability is like assault. When you challenge someone, you show them the knife, you challenge with your words, okay, or you hit someone, but you have intention. So that is under intentional tort. Okay, when we see the word statutory liability, this is the liability where it can be claimed under the statute. For example, if you refer to the contract last time, the contract itself may be referred to another statute. Okay, maybe one of the simple example that you can refer before, we are referring to the age of majority 1976 or 1973, where the person under majority only allowed to enter to the contract. So let's say you are not the person of majority, you are going to be claimed under statutory liability. Okay, and then the other one, we are going to see the relationship between vicarious liability with the tortious liability, because the vicarious liability also referring to the person who is responsible to someone else because of the relationship. Okay, a parent and the kids, the employer and the employee, that is vicarious liability. Okay, now we go to the vicarious liability first before we go in detail regarding to the law liability, tortious liability. Vicarious liability normally occurs when one person is held responsible for the negligence of the other. It also referring to you have to be responsible for the action done by another person within the employment relationship. This is what I did mention just now, between the master and the servant, between the employer and the employee, between the principal and the agent. So look at this example. These are the example under vicarious liability. That means if let's say you are the employee of this company, for example, you are doing something wrong, it will affect the reputation of the employer. Or if you are making something wrong, your employer has to be responsible because of your action. Okay, or maybe another one, a scenario, simple scenario, maybe because you accident, due to completion of the work on the construction site, employer for that particular area construction site has to be responsible to pay maybe certain amount of damages or hospitalization due to the scenario happen in the construction site. There are a few examples to make you have a simple impression on how the vicarious liability looks like. Okay, now let's move to the importance of the vicarious liability. Why vicarious liability happen? This is normally the reason is normally sometimes it is not easily contact with the employee because of the limited capacity, because of the reputation, and because of the payment, for example. So that is one of the reasons highlighted by the law. Number two, employer gets benefits from the employee's work. This is one of the argument where the employer has to be responsible if something happened to employee. Okay, and then the other one, in case where because of the act by the employee, someone would like to claim something, at least the employer can help the employee to get a certain compensation, secure actual compensation to the victim. And then the last one, of course, master or employer is having better financial standing to compensate the other third party in the case of negligence or in the case of what happened between the third party and also with the third party and also with the person who worked in that particular company or the employee. Look at this example. Employer may be liable for an accident caused by employee as the result of the negligent operation of the delivery vehicle, or maybe because of the negligent operation of the machine in the in that particular factory. Okay, so let's say the accident happened, employer has to be liable. Example number two, originally is not declared to be recognized by some of the jurisdiction, but because many of the jurisdiction has limited the vicarious liability between the parent and the kids because of the type of the action. Okay, generally we have to mention that the vicarious liability between the parent and the kids because of the domestic relationship. Okay, a domestic relationship means you have to be responsible to the kids because they have the domestic relationship. Parent may be liable to the kids, held vicariously liable for the negligence of their children. Let's say something happened where the kids are taking something from the supermarket. So the kids may not have any capacity to return back or to pay compensation. All right, who is required to be responsible? The parent has to be responsible for the action made by the kids. That is the meaning of vicariously liable for the negligence. Now we will move to the tort. We will move to the tort because when you see the type of the tort after this, you will see that especially under the topic of the negligence, vicarious liability is very important to be considered. Okay, what is tort? Previously, the simple way to explain tort is civil wrong. Okay, so this is actually one of the private law. We can say this one as is a private wrong committed by one person against another. It does not belong to your own self, but it is because of something or someone else. Even if you are falling down on the slippery floor, you also be able to claim who is responsible to make the floor to be slippery, unless that one is natural disaster and so on. But then you still are able to claim something because the tort allow the person to claim against another in terms of the one of the method is by monetary compensation. Okay, now let's look at certain branches of the tort. Number one, what is the tort itself, that one had been covered, and we have a different category of the tort, whether they are intentional or whether they are unintentional. Whether you have intentional to do so or whether you accidentally do so, negligently do so, that is under unintentional. Okay, and how does it serve? This is based on the element. So when you answer any question regarding to the tort, you have to explain how this element exists, how negligence exists, how trespass exists. Okay, so how does it serve? that is the answer is to see how the element itself has been established. There are few categories that you have to focus. Okay, we also referring to the defenses, where if you claim from someone, the person who bring the matter to the court is known as plaintiff. That means we also have to at the same time know what are the defenses that can be done by the defendant. So there are defenses and like limitation scope in this particular discussion. And then when you see the tortious liability, we always referring to the previous court cases. Okay, civil law cases. We also referring to the English common law principle and English common law cases. Okay, cases here are referring to the court case. So the court case that we refer is not only the court case in Malaysia, but also in the English common law or English, or you can say British colonial or Commonwealth country. Okay, so that means you can refer to the case from Singapore, from UK, from Australia, and so on. The scope for our tort liability for this subject is only limited to these three. We have another topic like defamation, but it is not covered because these three are very, very related to the scenario in the construction site. So we will focus on the trespass, we will focus on the negligence, we will focus on the nuisance. These three will be our next topic for the tortious liability. Okay, now we see how the tort actually come from. The word tort originates from the Latin words, the word tortus. Okay, so this one means twisted or wrong. Okay, so this word actually is the raw words or the original words that will create the new term like law of tort. Okay, the word tort itself signifies the word wrong, like civil wrong as what I did mention before. Okay, and then therefore a tort simply means wrong in its technical sense. Wrong, that means it is something against the law. It is something sometimes is against the law, sometimes it's because of the negligence of the other. That's why some of the tort also considered as criminal. Okay, so if the tort itself is criminal, you may be sued under two different categories. One is under criminal law, another one is under tortious liability. It may consist of either wrongful act or omission, which is not authorized by the law. This is what I did mention, because some of the tortious type are considered as criminal. The tort is the law of the civil wrong. Yes, this is also what had been highlighted. Normally, will allow the people to get compensation, allow the people or the plaintiff to claim for the monetary compensation when another person harms their legally protected interests. Okay, so this is actually to show you the aim of the tortious liability or the aim of law of tort. Now we move to the category in terms of the introductory. The tort law is broken down into various distinct of the type. Okay, so this is one of the example. As the introduction, you can see a person may sue in negligence when somebody has unreasonably breached a duty of care for another's interest. If we would like to identify whether the negligence established, we use the word established because you cannot simply claim that that person has carried out negligence to you unless you are able to show the elements on the establishment for negligence. Okay, how you want to identify that? Basically, we have to make sure that that person has owed a duty of care. Number two, they has breached a duty of care and you suffer damage. Once you suffer damage, you have to find the evidence that who are actually owe a duty of care. Look at this person. He actually falling down because the floor is slippery. So in order to be successfully cleared under tortious liability, what he has to prove? He has to prove that that person, or maybe the company, or maybe the person who taking care of this floor, maybe the company, has actually owe a liability to take care of the floor, to make sure that the floor is clean, not slippery. So that is the meaning of owe a duty of care. Okay, and then number two, the second element, this is example, the second element, he or the person who is actually for has to make sure that he has proof that the breach of the duty have happened. How we want to know that the breach has happened? Because you can see the slippery, you can see the water on the floor, and when the people pass through that, they actually falling down. Even though you can see the word caution, okay, but still, number 3 element is you suffer damage. Once you suffer damage, that is actually very good reason for you to claim from the person who owe a duty of care, even though the precaution had been happened. Okay, the caution sign had been mentioned there, but maybe because of this, and maybe because you did not taking care of yourself carefully, the amount of compensation can be reduced to maybe 70%. Let's say you claim for 1,000, you may get 700 only. So that is the example on how you want to claim under the tortious liability. We will look at this topic later under negligence. Okay, so now let's look at the concept and the features under the law of tort. The word that I put, the philosophy, are actually the term that you will see under law of tort. For example, when you see the word conversion, this conversion is not normal conversion. This is the conversion in the eye of the law. Okay, so every time you see the word conversion after this is actually covered under trespass to land. The purpose of conversion is actually to protect the movable property. And the second one, we have trespass to land, trespass to property, and trespass to person. Basically, the aim of trespass to person is protecting bodily interest. Okay, protecting bodily interest means someone cannot simply harm you. Someone cannot simply do something bad to you, because that will be because that person may be sued under trespass to person. Okay, nuisance and trespass to land. These two type of the law of tort is used to protect the land. Number 4, this is the topic where we did not cover in this subject, but then at least you know that defamation happened. If someone put the slander on you, you can claim because it protecting. This is supposed to be reputation, and R is missing. Defamation protecting a reputation. Okay. And then the next example, you can see the word forced imprisonment. If let's say someone take you and put you in the locked room for 1 week, okay, maybe because he would like to get something from you, forced imprisonment, or restrain you from going out, protecting the freedom of movement, protecting the freedom for you to go out, that falls under forced imprisonment. This forced imprisonment also under the category of trespass to person. Okay, so these are the introductory on the law of tort. Okay, for instance, if someone throws a ball and it accidentally hit a pedestrian in the eye, okay, any cost of medical treatment and compensation for the lost income during the time of work, because you have to stay in the hospital for maybe 2 months, you have to do operation, you have to stay in the hospital where maybe your employer say, okay, we have to terminate you. That one will be one of the item that can be claimed by the plaintiff, or could be paid by the defendant, could be paid by the person who threw the ball to the person who was hurt. This is the example where the person who hurt can claim under trespass to person, and also can also claim under negligence. Because trespass means if you can prove that that person has intention, you can claim under trespass, because trespass is required intention. But under negligence, not required intention, even though the person actually not having intention to do that, but because it is accidentally hit you, he has to be responsible. So when this person would like to claim under the law of tort, they will claim something that is beyond what you can see. For example, even though you can see that maybe I can claim only for the medical, fee, but the claim is not limited to that. They can claim under lost income. They can claim because the reputation have been affected. you cannot do your work for a few years because that will cause your eye to be, not healthy anymore, and so on. So that are the reason behind why you can claim the compensation and monetary damages for this particular law of tort. A tort may be committed through a wrongful omission, where this is another example. Ali deliberately or intentionally omitted to brake his car when he had clearly seen that Bong is the the plaintiff crossing the road. So with the result, when he hit Bong, Bong was injured. This is under tort of negligence, and this is under tort of trespass. If you can prove intention, you can prove you can say that if the person know, okay, you are crossing, but you still not be able to brake and you still hit him, that means you may have intention to do that. But let's say you accidentally, even if you brake, you also hit him, that is under negligence. So both considered as liable. Okay, so simple example is in the term of the accident. The tort allow a person, usually the victim, to obtain a remedy that serve their own purposes. Own purposes here, for example, payment for the medical, payment to see the psychiatrist, for example, payment to get due to lost income, and then obtaining the injunction relief to stop a person interfering with their business. Injunction here are also referring to the court order. Let's say you receive the threat from another person, or you receive the interference from another person, disturb your consistency of your business. So in order for you to stop that, maybe you don't have the power. What you can do, you can get the court order so that the person cannot interfere your business anymore. There is also some overlap between the crime and the tort. This is what I did mention. Some tort are also considered as the crime. Since tort considered as the private action, it is used to be developed more than for the criminal law, because the purpose of the criminal law is to punish. The purpose of the law of tort is to get compensation. Okay, if you would like to claim someone from someone is for them to get punishment, you will not get that, because punishment is under law of under criminal law. Sorry. For example, an assault is both a crime and also is both a tort. Okay, looking at this person, he just showed the knife. He didn't say anything. He didn't say, but because of that bodily movement, maybe because of the action, that is not allowed by the law by the authority. That is actually supposed to be falls under the crime. And then you can also claim the word assault is one of the category under law of tort. Okay, so basically the purpose of the remedies is damages. This is monetary compensation or injunction. This is what I did mention, injunctive claim from the court. Okay, so this is directing a person or to refrain person from doing something. Either the court asks you to do something or refrain you or to stop you from doing something. That is the meaning of injunction. Okay, this slide is actually to show the difference between tort and criminal in terms of the feature sense and in terms of the aim or the purpose of criminal and the tortious liability. Okay, criminal action on the other hand are pursued not to obtain remedies to assist a person, not to obtain remedies to assist the person in terms of the monetary value, although often criminal court do have the power to grant such remedy. But you can see that the remedy that have been claimed under criminal law is not as much as the remedy for incarceration. Incarceration means action in jail or prison. Okay, but this is actually to remove their liberty on the state's on the state's behalf. So that explains why incarceration or prison or jail is the usual is considered as usually available as a penalty for the crime. Okay, it is not sufficient to only pay compensation. Penalty for a criminal is always whipping, rotan, whipping, can be a prison for maybe 12 months, 3 months, and then not the remedy to pay to another person in terms of monetary. Okay, but this is not usually for the tort, because the tort is normally assist the plaintiff to get monetary compensation. So basically, in order to successfully claim something under the law of tort, the features of the tort are they must be a wrongful or considered as unauthorized act or omission done by the defendant. Okay, the wrongful or unauthorized act or omission affect the interests or the right of the others. Okay, that means the act by the defendant affect the act by the plaintiff. The act by the defendant affect the level of interest by plaintiff, or the act by the defendant cause the plaintiff to suffer damage. That is the meaning of second statement. The injured party or victim has the right to claim for monetary damages or injunction. So basically, the general rule is that an act or omission which does not give rise to an action for damages is generally not considered as the tort, because the aim is to get monetary compensation or damages. Okay, so now let's look at the fundamental concept in the law. Even though we are going to see the fundamental concept for each type, but this is the concept of the law of tort in general. Okay, number one, when we would like to explain about the features, the concept under the law of tort, we are referring to the liability. Okay, number one is always referring to liability. It always referred to the tortious liability where a person carry out something or does something that is not allowed, that is prohibited, okay, or does not do something that is required by the law. It is something that is forbidden by the law. Okay, we have also the author for some of the law specialists define a tortious liability as arising from the breach of the duty that have been sanctioned by the law. That means you didn't do something that is allowed, so you has breached the duty as the person who has to be responsible on your own action. Okay, so this duty is owned towards the public, generally the breach which may be redressed by an action for compensation. Any action that will affect another person or to the public is considered as the liability that you have to carry out. Okay, you have to be responsible on that, right? And then number two, we have the intention. This is what I did mention. Intention is considered as a state of mind and may be deduced from a person in two ways. Number one, where a person knows the consequences of his action. So look at the first word, consequences of his action. This is referring to you know the impact of your work. You know the impact if you do this. That is the proof that intention happened. That's why during the hearing, sometimes the judge will ask that person, do you know if you do this, the people will fall down? Do you know if you do this, the people will will be affected by the economical reputation, for example. Okay, when the person know the consequences of his action, do you know the reason and the impact for that action? Okay, and wish for those consequences to be for the plaintiff, that means the injured party, or they realize the risk but they still do that. So that is considered as intention. Number two, secondly, a man that is presumed to have intended the natural and probable consequences of his act. When you know something, you know the risk, but you still carry out that, that means you have intention to do that. So basically, a defendant whose conduct is foreseeable to give some rise to the infringement, this is said to be that the defendant has intention to commit something that is bad, or or have something like motive to carry out that to the plaintiff, because plaintiff is the person who suffer the damage. Okay, if he know what happened, if they know that because of his act, he foresee what is going to be the implication, that means the defendant has to be liable. Okay, so the word intention itself is always referring to the intentional thought. We always refer the intentional thought to the level to the trespass to person. Okay, and then even though they have intention, but sometimes because because the concept of the remoteness of the damage is applied, sometimes even though that person has intention, he may not be liable at the end. Okay, remote means small amount of damage. He may have intention, but the damage is so small, sometimes the court did not allow the plaintiff to claim under that particular compensation. Sometimes, okay, not all cases. Okay, now number 3, we also have the concept to consider regarding to the motive and malice. Basically, the law of tort is not concerned with the person motive, be it good or it is bad. Okay, because sometimes even though there is no motive, but you have to be responsible. Okay, this means that motive is actually relevant in determining the defendant's liability. Okay, relevant to see whether they are motive or they are not motive. If they have motive, that means they have intention. If they don't have the motive, maybe they don't have intention, but still has to be liable. But the word malice is referring to, this slide actually referring to the word malice, improper motive or intention. Okay, so the word malice is referring to any motive which law disapprove, or any motive if the law did not allow you to do so. Evil motive, improper or spite or evil motive. Okay, and then when you see the word malice, this is also referring to the intention, because this is intentional doing or synonym to the word intention of the wrongful act. Okay, so intention, motive, malice are all the items that the court will consider in establishment of the tort, or in order to show that the defendant is liable. Okay, concept number 4 that you have to consider is the word damage. Okay, you have to be able to differentiate between damage and damages. Damage does not have S, but damages has S. So that is the simple keyword for you to simply understand and remember. Damage is referring to damage to the property, damage to the property, reputation, damage in terms of the physical injuries, maybe the leg has been broken, okay? And then another one is also referring to the economic loss. Okay, damage to reputation, damage to property, economic loss. And then number 5, we are referring to the word damages. So damages means in terms of monetary compensation. This is what I repeat so many times, where the aim of the law of tort is to get monetary compensation that the plaintiff is ordered to pay to the plaintiff. Sometimes the amount of the damages have been identified by the plaintiff, but sometimes when the plaintiff claims for a certain amount of money, the final judgment will be considered by the court. They say the plaintiff is able to prove that he lost 5K, for example, or maybe 500,000 because of the defendant's action. So the court will evaluate how you come up with the word 500,000. Okay, maybe like daily you will get 1,000, but because of the defendant action, you only get 500 daily on your business. So that is how they claim and they evaluate the amount of damages. Previously, you don't have to spend a lot of fee to see the doctor, but because of the defendant action, you have to go and see the doctor like twice a day, or maybe 2 days, once in 2 days. Okay, 1 in 2 days or 1 in a week. So the frequency of meeting the doctor is there, so you can claim for that particular compensation. Right, when we are referring to the damages, you can also see the difference between the type of the damages happen in the law of contract. Previously, we have liquidated damages and we have unliquidated damages. So for law of tort, we always refer to the unliquidated damages, where the amount of compensation can only be measured after the occurrence or after the defendant's act happened. They cannot, because we cannot predict what is happening. Okay, and then we cannot know, we did not know what is actually happened, because sometimes it is happened because of the negligence. It's happened where it is not related with the contract, so it is beyond that. Okay, so damages for the law of tort is always be unliquidated damages. Okay, this is actually the summary to identify the category of the item that you have to consider, the concept that you have to consider under tortious liability. Okay, this is just the summary, but you can refer to this one later when we finish all the topic under law of tort. With that, thank you very much. That will be the end of the discussion for the introductory for the vicarious liability and also the concept of law of tort. Thank you everyone. Assalamualaikum warahmatullahi wabarakatuh.